Hello and welcome. My name is Ali Goff. I'm the owner and founder of Goff Legal. We do estate planning, serving clients throughout California. This video is designed to explain to you how we transfer real estate into a trust. Now, if you've hired our office, we're doing this for you. But if you haven't, or you're curious about what this looks like, I'm going to give you the process. So every piece of real estate has a legal description and is recorded in the county recorder where the property lives. So Placer County, it's going to be the Placer County Recorder's Office. And every property has, in order to know who owns it, this chain of title from when it was first purchased and then how it got to the next place are called deeds. So deeds are created usually by lawyers, sometimes by title companies as part of a transaction to show and prove in the record, the public record, who owns what properties. So a deed contains essentially contact information, name, legal description, who owned it, who's it going to, what type of deed it is, quitclaim deed, grant deed, all sorts of different things. I'm not going to go over the anatomy of a deed, but just know that there's some really important and necessary information that goes into a deed, signatures, notary blocks, etc. So the way we do this is we pull the title from the previous, whatever the ownership is, so whoever owns the property right now. We look at that and then we create a new deed that says, okay, if these were the owners, Sally and Sue, married couple as community property with the right of survivorship, transfers to Sally and Sue, trustees of the Frankfurter Family Trust or trust, right? You see previous owner, current owner, legal description, sign, Sally, Sue, and then we go ahead and record it. We use e-recording because that's how most of the things are done now. We pay the fee for you. We track the progress. We make sure everything looked good. We also included a PCOR, which is a preliminary change of ownership report. It is a necessary form that goes along to the assessor with every single transfer that says, is this a reassessable event? Should we reassess the property taxes as a result of this particular transfer? The good news is for assets that you own in your individual name, if you're putting them into a revocable trust, there is no reassessment, but we have to tell them that. It's important that we give them that information. Fun fact, if you miss that form, it's $20 extra. Don't miss that form. Don't miss that form. Then in a matter of, I think, honestly, minutes now, it used to take weeks. We would mail it in, sometimes months. Mail it in, they'd record it, they'd send back the original. Then they got online e-filing. Our firm has signed up and for that service. And so we can e-record, not e-filing, e-record deeds, which means we get them back really, really quickly. Put a copy on the deed, put it in your binder, off and running, and you're done. So you know it's in the trust when it says the to, I so-and-so grants to the name, which would be the name of you as trustees of the name of your trust, including the date, and it's recorded. That's how we put real estate into your trust. Like I said, if you've hired our office to do your estate plan, we will handle the real estate for you. If you have property outside the state of California, it's probably a very similar process. Exactly how it looks, I'm not really sure. And we don't prepare deeds for out-of-state properties, but we can connect you up with attorneys in that area or handle the facilitation of that for you. If in fact you have a California trust with some assets and some out-of-state property, we can make all that work for you. All right, hope this has been helpful on how to fund a trust with real estate.